Welcome. My name is Rebecca Critser. I'm an assistant professor at Johns Hopkins Bloomberg School of Public Health, and I will be moderating tonight's webinar titled Approaches to Teaching Standing. By way of background, the Animal Law program at George Washington University houses the Animal Legal Education Initiative, which is dedicated to developing animal law as a standalone legal discipline that is fully integrated into the legal academy. In support of that mission, the Adjunct Teachers in Animal Law webinar series has been created, and you can find previous installations of this series on the YouTube page. Now, if you've had the opportunity to attend or watch a recording of a previous webinar in this series, you'll notice that today's topic and format are somewhat different. This is the first of several substantive law webinars that we will be hosting, and today's topic will be on standing. And we are going to hear tonight from Paulina Damaso, a student at UIC Law, Dr. Reddy from Lewis and Clark Law School, and attorney Jessica Blome of Greenfire Law. Now, while we still want to encourage ample audience questions, interactions, participation, our panelists are going to provide presentations on the topic of standing by way of background to get the ball rolling. We will begin with Paulina, who's going to speak briefly about her experience in learning about standing as a student. We will then hear from Dr. Reddy, who will walk us through his approach to teaching this topic. And we will conclude with attorney Jessica Blome, who will provide insights into standing from a litigation and practice perspective. Generally, we're going to reserve questions for after the presentations. There will be plenty of time then to get your questions in. So please make sure to either put them in the chat when they occur to you or go ahead and jot them down and hold on to them for our Q&A. And our Q&A session will look more like our traditional open format. You're going to be invited at that time to unmute yourself and ask questions verbally if you so choose. At the end of the presentation, we will ask you to unmute to ask questions. We do ask that you stay muted unless asking a question, and that if possible, especially during the Q&A side of things, that you have your cameras turned on, as it makes it a more engaging conversation and experience for everyone. Do want to remind you, this session is being recorded. It will be uploaded to the YouTube page that was previously mentioned. So, without further ado, I would like to turn things over to Paulina to discuss her experience with legal standing in both animal law courses as well as other legal courses. Paulina.
Hi, thank you for that introduction. So again, I am Paulina. I am a student, 3L2, so my last semester at UIC Law. To begin with, I'll speak more generally along the lines of my experience in law school, and then I'll go further into details of constitutional law and standing. So first, I would like to start with, so some of the classes that have stood the most out to me have been classes taught by professors that genuinely enjoy teaching the topic. So in this sense, it helped pique my interest because of the professor's enthusiasm, professors that did not hide the ball on information, being direct and concise on a specific topic or a certain question. On the other side of the scale, the opposite can be said, where my view on classes where I thought I would enjoy the class turned out to turn a little bit sour because of maybe a professor's monologue for the whole course, or not wanting to hear from students' perspectives, or having a students are wrong mindset. That will move me forward to generally towards participation. So I benefited from cold calling during my first year of law school. It might be a little bit controversial to say, but I enjoyed it because it helped me with my confidence. I was experiencing a new environment for the first time, so this helped, especially with difficult topics such as standing. This helped with a reference check for the professors to see where students were in understanding the material. It encourages engagement as well, because this is kind of a secret amongst law students, is that if a student knows that they may be called on, there's a higher chance they will read thoroughly for the class and therefore be prepared and engaged. A little note that I would like to also add is that not to make it into a punitive approach. So the cold calling, it might overwhelm or frighten some students. And also another way for participation to be encouraged besides cold calling would be allocating more points for the overall grade, such as 10 to 15% of the overall grade for participation. Now I'm going to move forward for more specifically during constitutional law. So, unfortunately, I do not have any notes from this course because my professor forbade computers during class. So, all of my notes are handwritten. I have a ton of books at home. I am unfortunate enough to have been organized my first semester of law school, so I do not have any notes on this. So one aspect of the class that I do wish was different was that I had those notes for constitutional law, especially now since I will be studying for the bar and for the future reference in general. What I do remember from my constitutional law experience is the differing opinions about how the justices interpret standing requirements and the specifics and theoretical approach. So, textualism versus originalism, that's a theoretical argument that might not be touched upon in every con law class throughout the board, but I enjoyed because the Constitution can be seen as a document that should be interpreted as it is by its text versus the Constitution being a living document that changes based on its interpretation. So these theoretical discussions help me understand today some social conflicts of when laws are being stricken down or upheld, and overall, just these social aspects will are this constitutional discussion will help with social aspects today. Another thing that I benefited is my professor was generally honest about the material. So he considered standing as a way for the government to broadly regulate, even when it didn't really make sense to. And I think those notes and those comments really helped me understand that there's different things that are going on behind the scenes as well. Um, Another thing I would like to mention is that on the topic of standing and the emphasis of the separation of powers, that also was helpful in guiding me to understand that the courts are not there to decide legislation. Courts are just the interpreter of laws and not really the do-all be-all of making and enacting new laws. That is for the legislature. And that's generally what I do remember from standing. Reviewing the material now, it is complicated. As a 3L2, it is still complicated, but it is similar but different from other material in law school because we're always looking for where the line is drawn for how a judge may decide on an issue in court. Knowing where that line is drawn on standing may be more tricky than other topics, such as contracts, where there's not going to be a major Supreme Court case decision that comes out today on the parole evidence rule or something like that. Otherwise, for constitutional law, there are major Supreme Court cases that are happening every day, not every day, but more often than not than contracts. Um, Generally, for standing again, for animal law. Now I'm moving to animal law. So animals cannot speak or communicate, which makes it harder to confirm redressability or injury in fact by the court to show standing. That is something that stood out to me when I took animal law. And the access to justice generally, and more specifically for animals, during the animal law course, the emphasis on animals are property under the eyes of the law was very important in every aspect of this course. So the question arises whether there is enough access to justice when the animals lack the legal right to sue. Dismissal for lack of standing was a common theme in the course, which I learned from constitutional law as well, a pathway for courts to not decide on an issue. Thank you.
Thank you so much, Paulina. That was absolutely wonderful. I think it's really great to have the setting of a student perspective to set us up because I think as professors, we're always trying to get in that mindset in order to do the best that we can to teach and provide you the materials. So thank you for that. And now we'll turn it over to Dr. Raj Reddy, an assistant professor of law at Lewis and Clark Law School, where he directs the animal law program at the Center for Animal Law Studies. Take it away, Dr. Reddy.
Thank you. And let me just can you see my screen? Okay, wonderful.
Yes, looks great.
Um, Thank you. So obviously, a very complicated and involved sort of area of the law, one that, you can't necessarily cover in just 20 minutes, but I'm going to be offering a bit of an overview of my talk. Principally, my concern or what I would like to do today is relate the concepts of sort of rights, personhood, and standing, and then touch upon some standing requirements, both constitutional and prudential, focusing, principally in the federal context, and then, observe what this framework has sort of entailed in terms of barriers to standing for both advocates who are trying to advance the interests of animals, as well as standing barriers for animals themselves. So really getting into some of these implications of animal standing and personhood. And then if I have time, some pathways to potential pathways to animal standing. So with that said, starting with, this concept of what are sort of rights, personhood, and how do they relate to standing. When I teach this area in my animal legal philosophy class, at some point during the course, I really turned to Steve Wise's pyramid. And I have an asterisk there because I change in some ways, and I can talk about it maybe during Q&A. His rights pyramid, which first appeared in the Animal Law Review in an article several years ago, as a means to sort of get students to appreciate how these aspects of standing sort of interrelate. And so in Steve's framework, he reverses personhood and rights from what you see here. But the way I like to think about it and the way I like to explain it to students is that, one has or one creates a right. And from that right, you have entities who have the ability to enjoy that right. And so those are sort of legal persons. And if that right provides a private action for one of those persons, then they have the ability to go to court. And at that point, they have to demonstrate in the federal context that they meet the constitutional standing for requirements, as well as the prudential standing for requirements, prudential requirements for standing. And you can kind of see that that topmost aspect of this pyramid as bifurcated. So constitutional on one side and prudential on the other. But just to offer us a little bit of an example, if we're thinking about the federal law that governs copyright, so what is that law? What's the law that provides this right, that gives you control over creative works that you've developed, scholarly works as well, and the person who's created from this law, this statute, is the copyright holder, and there is a private right of action in copyright, so you do have the ability to sue, and if you can get to court then, and you can demonstrate again that you've met these standing requirements, which I'll touch upon later, you've basically sort of met all of the requisite elements to basically make your case. And this is a very sort of simple framework, but there are examples where things get a little bit more complicated. And so for my students, I try to break those down as well, the nuances. And so for those of us who are in academia, we're pretty familiar with, FERPA. So this right that students have, or I shouldn't say students necessarily, but the right that a potential individual has in their educational records. So you have this privacy interest in these educational records, but interestingly enough, the right creates potentially two legal persons. And so one, if you are under sort of 18, the actual person who's created, the person who enjoys this right, is sort of the guardian of this person, of the student in question. If you're 18 plus, then the right sort of belongs to you. You are the person under FERPA who enjoys this right. And so again, the law, this particular statute, provides for two different pathways, provides for two potential different persons. And so, if you are a middle school student and someone has violated, this FERPA, this interest in your educational records that you have, you may not have the ability to do anything about it if your parent or your guardian doesn't want to act upon that particular right. So again, the personage sort of aspect can be quite nuanced. Also interesting is that, FERPA does not provide for a private right of action. So even though you possess the right, even though you are the person who's created by this right, you don't actually have a private right of action. You don't have the ability to sue. You can bring your injury basically to the Department of Education, who then would have standing to effectuate that right on your behalf. So again, it's not always as simple as in our sort of copyright example. Just bringing it to the animal context, so the Animal Welfare Act, this right to see animals treated well in these particular contexts, in exhibitions, research and testing, and by dealers. So I'll put an asterisk here because there's some question as to in which context who is a potential sort of legal person, but there is a private right of action. So someone whose interest is violated has the ability to sue, and they could again go to court and make their standing sort of argument. But if this gets to this question now, what is standing, and what are sort of the constitutional elements of it under Article 3, and what are sort of the prudential elements of it as conceived by the courts. And so in the constitutional sort of framework, you have your injury and fact requirement. This injury that you experience has to be concrete and particularized. It has to be, if it's a future injury, it has to be sort of actual or imminent. Causation is usually not an issue in a lot of our animal cases, so I won't necessarily touch upon that. But it also has to be subject to redress. So the law has to be able to provide relief, the law that you're suing under, and you have to be able to, as the plaintiff, enjoy that relief. And again, those are Article 3, constitutional standing requirements. And what's more interesting, I think, is the prudential standing requirements, which are basically created by the courts without any sort of constitutional requirement they do so. And because of a significant number of lawsuits being brought in federal courts, the Supreme Court developed this zone of interest test in order to create some sort of guardrails on what sort of claims can be brought under particular statutes. And under this zone of interest test, that relief has to fall within the particular zone of interest contemplated or protected by that statute. And the way I like to break it down to my students is, two basic questions. Did Congress intend this particular plaintiff to enjoy this particular interest? And we'll touch upon those with some examples here in a moment. But I also sort of want to mention before we move on, you have, in addition, sort of associational standing, where you have sort of a membership-based organization where the entity is suing on sort of behalf of one of their members who's been sort of injured. And in order to sort of meet the associational standing requirements, those the interests that you're seeking to protect as the organization have to be germane to your purpose, and neither the claim nor the relief necessarily has to require the participation of that individual member or members in the suit. There's also Haven's organizational standing. And under this particular framework, the org has to have suffered some sort of economic harm due to an agency's sort of illegal conduct. So that can be sort of anything that violates a statutory requirement. That can be action or inaction that forces you as the organization to really redirect funds to, redress yourself the injury that you're experiencing by virtue of the agency's action or inaction. And that agency action or inaction has to sort of perceptibly impair your ability to serve your members or carry out your mission. So again, I won't go into those too much in depth, but just know that there are also issues that come up in a number of animal law cases. So what I find really exciting to talk about and what my students are really interested in is, what are the barriers for animal advocates to be able to, bring these cases on behalf of animals? And, a lot of these issues, as we'll see, implicate this question of whether animals are legal persons, whether the right necessarily was supposed to flow to them. So looking first at the constitutional side of things, oftentimes we find in these animal cases that that the individual, the human or the organization who's trying to effectuate this interest on behalf of an animal under the Endangered Species Act or the Animal Welfare Act, for example, that individual or that organization wasn't able to directly experience some kind of cognizable harm, maybe because the animals were sort of kept away from them, they weren't able to see them, or for some other reason. Also, potentially because that the law potentially wasn't applicable, or because they wouldn't be able to sort of see the animals again, so they wouldn't be able to experience the benefit from that redress. And there are a number sort of examples of this. For example, the Lujan case, where a number of advocates were suing to protect endangered species who are going to be affected by this government-supported development in other countries. Well, they failed to demonstrate that they were actually going to be able to see these animals being harmed, and they had no sort of plans to go to those places, those far off locales, in order to, even if the court, ruled in their favor, to experience then the benefit from that redress. So they really just didn't demonstrate that they met these constitutional requirements. And again, I think more interestingly, in the prudential side of things, a number of cases have failed because um, the particular advocate has failed to demonstrate that their interests fall within the zone of interest contemplated by a particular statute. An example of this, ALDF versus SB. So this case where ALDF was arguing that that they suffered this informational injury because they weren't able to get certain data from related to the use of animals for research and testing purposes. And here, the court said, well, did Congress intend this particular plaintiff to enjoy this particular interest? And because it was in the context of research and testing, the answer was no, because Congress did not necessarily contemplate the interests of individuals to enjoy sort of animals being treated well in the context of research and testing, because those particular venues, those particular industries don't necessarily open themselves up to the general public as distinct from an exhibition, so like a zoo, for example. And so for numerous reasons, there could be cases where, a particular statute zone of interest don't necessarily contemplate the particular interest of an organization or an individual. And again, that's a pretty compelling example. Of course, there are a number of examples where advocates have been able to overcome these barriers. I think the principal case is ALDF versus Glickman, in which the plaintiff in that case, Mark Jernove, was concerned with the USDA secretary not having promulgated appropriate sort of standards to provide for the interests of the psychological enrichment of primates. And so this particular plaintiff, Mark Jernove, went to this game farm several times, experienced directly the suffering of these animals. And because he demonstrated that he had continued plans to continue to go to the game farm, that he would have his injury redressed if the court ruled in his favor. And in observing sort of the zone of interest contemplated by the Animal Welfare Act, the courts were able to determine, yes, Congress intended this particular plaintiff to enjoy this particular interest, this interest in seeing animals treated well in this particular type of industry. So that's a little bit of the constitutional barriers and prudential barriers for animal advocates. In my animal legal philosophy class, I'm more focused on standing barriers for animals and how, again, these barriers contemplate or implicate issues related to sort of rights and legal personage. And I'll just go over a few examples and hopefully provide some nuance for those of you who are contemplating talking about animal legal standing in your con law classes or otherwise. Some of you might be familiar with this animal, the Paulina, the species that was once vibrant in Hawaii, but was suffering because its habitat, the Mamei forest, was being basically eaten away by this feral goat population. And the question was the Hawaii Department of Land and Natural Resources attempt to address this by creating a fence going to provide for the interests of the Palula under the Endangered Species Act. And so it's important to note that this is a Ninth Circuit case, district case. And so the plaintiffs listed the Palula in addition to themselves, so the Sierra Club. You also had actual individuals as named plaintiffs. And again, you had the Hawaii Department of Land and Natural Resources. And in this case, what the court said was, yes, the Endangered Species Act was passed to provide for the interests of individual animals or animals at the species level, I guess I should say. And so necessarily the Palula appropriately sort of flies into this court as an appropriate plaintiff and, hence here the named plaintiff as well. And capturing this for students, I think, is really important. And I'm going to be focusing more here on the left side. But with respect to, this question of what the right is, well, the right is to protect endangered species and, who holds that right. And under the Endangered Species Act, it provides that any person can hold this right. And so with respect to the judge in this particular case, the judge determined that, well, looking at the zone of interests, and trying to answer this question as to whom did Congress want to equip this right to. That includes the Palila. And so again, we turn to Congress to sort of answer this particular question. And so for sort of framing this out for our students, this can include humans and human organizations and particularly listed species under the ESA. So again, the jurisprudence here was that this includes those beings who are protected by the statute. And of course, the Palila are necessarily going to be the ones who are directly harmed and the ones who are necessarily going to experience the benefits. And so, the implications for the rights and personhood sort of analysis necessarily is going to sort of carry over to the constitutional standing analysis as well, again, assuming that that's answered in the affirmative. And a lot of folks don't know that there are a number of other circuit cases that have basically arrived at the same sort of conclusion. So in the Third Circuit and the 11th Circuit, we have a couple cases that have listed species as the named plaintiffs. And those courts have said, well, either it's not sure as to whether, animals can be or species can be listed plaintiffs, or that species under the ESA have standing to sue sort of in their own right to enforce provisions of the Act. So a number of other circuits have provided for these same kind of pronouncements. And to explain this to students, again, we can kind of go back to this pyramid. We have, again, what the right is to have species protected from extinction. And at least with respect to Palila, it can be humans and it can be animals, or at least species who are listed under the ESA. The ESA provides for this private right of action. And again, we get into our standing analysis. And what I find really compelling and what my students really appreciate is how this has been sort of interrogated by subsequent courts. And so some of you, or many of you, may be familiar with the Cetacean Community v. Bush case, another Ninth Circuit case, and this reached the Ninth Circuit Court of Appeals. And here you had a number of advocates who were suing on behalf of cetaceans basically all around the world. And in this case, there were no listed humans. And again, some of the issues that we often have, or we often find when we're listing ourselves as plaintiffs, is that we're not the ones who experienced that direct harm. Or we can't even get access to those locales where these animals are going to be harmed in order to evidence that, we have, again, suffered those cognizable injuries. And interestingly here, the court said, well, that finding of standing for the Palila in the Palila case was merely dicta because it was not outcome determinative. The court in that case was able to arrive at the decision that the Hawaii Department of Land and Natural Resources wasn't sort of fulfilling its obligations without sort of relying on the Palila as a named plaintiff, because again, you had other named plaintiffs who were humans and who necessarily had standing under the ESA. But the court in its analysis observed that, it's not that animals can't meet these constitutional standing requirements. Obviously, they can be directly injured. It can be caused by the action or inaction of the state or some other entity. And the animals would necessarily feel the redress. But the court really sort of honed in on this prudential question. So again, this notion that if we are going to sort of move forward with this, we need to ensure that Congress really, as the creator of that right, wanted that right to give rise to animals as legal persons. And that can be directly through the statute or again through that APA zone of interest test. And so at least after citation, where we are now is that, under the ESA and again in the Ninth Circuit, that only humans can be possessors of these rights unless, Congress lets us know otherwise with respect to the ESA. And again, that can be through an amendment to the statute or some sort of signal that their interests are contemplated by sort of this zone of interest tests. And I just want to touch upon just a couple of examples or a couple of cases that have come after this particular case where advocates have tried to sort of negotiate around this particular outcome. So you have, some of you might be familiar with the Tillicum case. And in that case, I think the foundational argument was, well, this is not sort of a federal statute that we're talking about. We're talking about this constitutional amendment providing that involuntary servitude shall not exist in the U.S. except for someone who is sort of duly incarcerated. And so the zone of interest just doesn't even apply. So we don't necessarily have to worry about sort of those prudential elements. We can kind of just go to the constitutional elements. And so in bringing this case, PETA argued that Tillicum was being forced to engage in this involuntary servitude at the hand of SeaWorld. And in its determination, the Ninth Circuit argued that no, unfortunately, while Tillicum might have been directly injured, while that might be caused by SeaWorld, that the 13th Amendment does not apply to non-human animals, and so the law can't possibly be used to redress the injury that they've experienced. Some of you might also be familiar with the Naruto case, where this Japanese macaque took a picture of himself, and the question was, well, who's the owner of that, the copyright of that image? And PETA sued on behalf of Naruto here, arguing that he was the owner of that copyright. And, kind of going back to that pyramid example, here, the court said, well, no, only humans can be owners of copyright because that's what Congress intended. Congress did not intend for elements of nature in any way, shape, or form, or AI or animals to be owners of copyright, only humans. And so again, to go back to sort of that pyramid, and the way I explain this to my students is that, what's the right in question? Well, this right over created work. Who's the copyright owner? Or who's the person created by that? Is the copyright holder, and that includes just humans. And so we don't necessarily even get to this question of non-humans' ability to have sort of standing. And I want to touch upon, just in closing, some implications, I think, both moral and legal, with respect to this prospect of standing on behalf of animals. With respect to sort of that Naruto case, a number of questions have been raised as to sort of the ethics of bringing some of these potential sort of arguments. Do non-human animals have an interest in copyright such that we should be bringing these cases on their behalf? Did PETA actually know Naruto? Had they ever met Naruto? Did they know Naruto was alive? Answer to those questions were no. And so to what extent can we, as animal advocates trying to advance the interests of animals and trying to advance, arguments for their legal personage, are we potentially undercutting ourselves and our arguments, our moral arguments, and our sort of ethical duty as lawyers, if we can't sort of answer some of these fundamental questions, or if we don't address those fundamental questions? And with respect to a couple of the other circuits that I talked about earlier, I can't remember if it was in the 11th or the Third Circuit, one of those two cases. There was a question as to whether the human plaintiff in that case, in addition to the non-human animal species, if they were really bringing this case under the ESA to protect that particular species, this loggerhead turtle, or if they were doing it to prevent the development of this project because they didn't want their home value to be eroded. And so there's this question again of how can we offer assurances that when we are bringing these cases on behalf of animals, arguing for their legal personage, that we are making clear to the court that we're offering the court sort of appropriate assurances that we have sort of their best interests at heart. And I'll close in saying that a lot of these questions, I think, for those of us who teach animal law or teach constitutional law need to bring to the fore for our students to consider because the implications, reach far beyond some of the cases that we'll be bringing, but can make judges sort of question sort of the prospect and the ethics and just the logistical sort of parameters around sort of legal personage for non-human animals. And I think if we can answer those questions as a collective and put parameters on it ourselves, then how can we necessarily expect the courts to do that? So I think I will stop there.
Thank you so much. That was wonderful. I learned a ton, as I knew I would. And get excited for the Q&A to come. And also congratulations on hitting the 20 to 30 minute marks right on the dot. Very well done. But before we get to Q&A, I am excited to introduce Attorney Jessica Blome, who is an animal, environmental, open government, and land use attorney with nearly 20 years of experience in complex litigation. And I'm very excited to hear from you. I will turn it over.
All right, hello everybody. Let's see if we can screen share here correctly. All right.
So I can't remember if you want us to see your notes. I do currently see them.
No, it'll make sense in a minute. There, did it work?
It looks beautiful.
Okay, so you can see just the PowerPoint. Okay, well, hello everyone. I know we're in different time zones, so good afternoon, good evening, wherever you are. I'm, as Rebecca indicated, I'm Jessica Blome. I'm a shareholder with the law firm Greenfire Law, which is a public interest environmental law firm and animal law firm located in Berkeley, California. So I'm on the West Coast today. And I'm very happy to be talking to you about what it means to stand up in litigation as a practical matter to protect wildlife. I'm going to talk about two cases today that I've personally litigated all the way through trial. The first involves an Endangered Species Act case against the owners of the Cricket Hollow Zoo in Iowa, and the second involves an Endangered Species Act case against the Florida Department of Environmental Protection for take of manatees. So first we'll talk about the Cricket Hollow Zoo. I always like to do a little scene setting with the Cricket Hollow Zoo because not everybody in the country is super familiar with where Iowa is located. So here's where Iowa is located in the map of the country. And then in the top right-hand quarter is where you would find the Cricket Hollow Zoo. It's an extraordinarily rural area. The nearest city, proper city, is 3 hours in either direction. And those cities only have about 150 to 200,000 people each. And the Cricket Hollow Zoo itself was both a zoo and a dairy operation. And that is visible on this slide. So you can see here from an aerial shot of the property, the zoo portion, which is surrounded by farmland. And then on the right-hand side of the image here is where she had her dairy cattle, where she kept her dairy cattle. And all day long, she'd go back and forth between the dairy barn and the zoo area, which posed some significant risks to the exotic animals that she kept in the zoo and caused the death of a fair number of them. So we brought the lawsuit under the Endangered Species Act. I represented the Animal Legal Defense Fund and 4 individual plaintiffs. The Animal Legal Defense Fund did not sue in its own name. So they just represented its members And that meant that they did not seek organizational or associational standing, as Professor Reddy just explained. They only sought standing on behalf of the individuals who are suing. Under the Endangered Species Act, it is unlawful for any person to take any species in the United States. And that term means to harass, harm, pursue, hunt, shoot, wound, kill, trap, capture, a whole bunch of bad words. You can't do any of those things to endangered animals in the United States. Prior to this litigation, nobody had successfully used the Endangered Species Act to protect wildlife in captivity. It had only been applied successfully to wildlife in the wild. So this was really a groundbreaking case. I'm going to talk today about harassment of lemurs. And this is important because, as Professor Reddy indicated, the way the statute is set out and the way that the regulations implement the statute is relevant to your standing because you have to meet that zone of interest test. So you have to specifically prove that your plaintiff is harmed as far as injury in fact by what the statute is regulating. Here, the harm and harassment prohibition is what we have to prove is a violation of that prohibition is we have to prove that our individual plaintiffs are injured by the violation of those prohibitions. So harassment is an intentional or negligent annoyance of an endangered or protected species that significantly disrupts their behavioral patterns, which include but is not limited to breeding, feeding, and sheltering. And for captive wildlife, it matters that those interruptions also are non-compliant with the Animal Welfare Act or generally accepted animal husbandry standards. So that put a whole bunch of elements of proof at the forefront of the case. And we had to use those elements of proof to connect to the injuries suffered by our plaintiffs. So Professor Reddy went through the traditional standing test for case or controversy. You have to have suffered an injury, in fact, just a little reminder, that's concrete and particularized, actual or imminent, and caused by the defendant. That injury must also be redressable, which means that the court can implement a remedy that would lessen, doesn't have to entirely eliminate, but at least lessen or weaken the injury that you are suffering. In these cases, we almost always use the aesthetic injury theory of injury that injury in fact that Professor Reddy discussed from the Glickman case. This is a groundbreaking animal law case in which the attorneys were able to successfully argue that Mr. Ken Jernove had suffered injury to his own cognitive and emotional and recreational and aesthetic interests as a result of witnessing non-human primates in captivity in terrible conditions, in isolation, in filth, in just absolutely deplorable conditions. For his part, Mr. Jernove visited the zoo over several years. He developed an emotional attachment to the animals that were in the cages, and he really spoke eloquently and meaningfully about his experience just connecting with those animals and when he watched their suffering and the advocacy effort that he undertook with the federal government in order to alleviate their suffering. The Cricket Hollow Zoo housed 3 endangered species. They housed lemurs, tigers, and wolves. I'm going to talk about lemurs today because I want to get to manatees. So with respect to lemurs, they are their own individual species. And so in many ways, when you're looking for that ideal plaintiff who would be able to establish that they have standing in order to sue over the Endangered Species Act, you need somebody who's connected with or has a unique relationship with these non-human primates specifically. And so for this reason, my standing plaintiffs and my plaintiffs divided up into 2 categories. 2 of them were really connected to the lemurs, and 2 of them were really connected to the wolves. And one of the tiger folks had a relationship with the wolves so 2 lemurs, 2 tigers. One of the tiger folks had a connection with the wolves. And with their testimony, I really focused on those relationships that they had developed. These were just 4 individuals who had visited the Cricket Hollow Zoo over time. 2 of them wrote an op-ed in the newspaper of their very small town describing the conditions at the zoo and how horrified they were. by those conditions, which is how we found them from the Animal Legal Defense Fund. We called them and we said, hey, I'd like to hear more about what it is that you saw when you went to this zoo, what your experience was when you were looking at and visiting the animals, and what about that stayed with you, so such that you felt you needed to write this op-ed. And they described individually this extraordinary effort that they had undertaken for the past 5 years to get better conditions for these animals through advocacy to state and local government officials, to the district attorney, and to the federal government at the Animal Welfare Act. Two of my plaintiffs, the Keels, had actually secured meetings with USDA inspectors and higher ups in the USDA's Animal Plant Health Inspection Service to try and convince them that they needed to do more for these animals. That's really all we needed to hear at the ALDF to know that they likely had met the standing test, because they had undertaken such an extraordinary effort due to the aesthetic and emotional injury that they had suffered to protect these animals. And the only way for their injuries to be redressed would be through court action. So this is a picture of a healthy lemur in captivity, of course. You can see that the rope above him is, that's not existing in the wild. This lemur is likely from the Duke Lemur Center, which is a world-renowned lemur center in North Carolina, where our expert Peter Klopfer worked and studied lemurs for his entire career. So the first plaintiff we're going to talk about is John Brauman. I have excerpted a little bit of his deposition transcript so that you can see how emotionally he spoke about the lemurs that he saw in captivity at the Cricket Hollow Zoo. Pictured here is Chucky. Chucky was an isolated lemur who, for all of his time at Cricket Hollow Zoo, which was about 15 years, either lived in isolation or with one additional pair in his enclosure. At the time that John visited the zoo, Chucky was in isolation. He testified he was angered to see this lemur by itself in a cage and vividly recalled the photo every time he thinks about the zoo, and it angers him because he knows how social they are. So we used his testimony not only to get in some facts about the conditions at the zoo and Chucky's confinement, but also to show standing that our plaintiffs had been aesthetically and emotionally injured by the conduct that was happening at the zoo. This is interesting because we also were able to successfully use these individuals' connections to all the non-human primates, not just Chucky or Lucy, the other lemur who lived there, who were the two endangered non-human primates. But here we have a baboon that the owner of the Cricket Hollow Zoo used as her ambassador animal. And she had taken this animal from his mother when he was born and raised him in her home. And this was so distressing to John Brauman. For the rest of his life, every time I talked to him, he asked me about Obi. Obi eventually died due to complications from stereotypic behavior that he was suffering at the Cricket Hollow Zoo. And this absolutely crushed John Brauman, and he had to withdraw from any further participation in the case because he couldn't continue that level of emotional investment. But you can see here he's just depressed. He talks about his depression in this deposition transcript. The other individual who testified about the lemurs was Nancy Harvey, and she was such a great witness on emotional distress related to her witnessing these manifestations of interference with these animals' social and natural behaviors. She talked about being anxious, upset, depressed, not very hungry, not eating, not sleeping. The judge was very persuaded that that these individuals all had suffered this aesthetic injury, and that it would be redressed if he did something. The thing that we had to prove was causation, that the behavior or conditions that the owners of the zoo had put in place for these animals was what caused their distress, not some intervening factor. And so we used a lot of evidence from the United States Department of Agriculture itself to demonstrate that the zoo owners were wholly incapable of complying with the with the law, and that they had undertaken these um, that they had caused these violations and caused the suffering of the plaintiffs. In addition to the, I mean, obviously, in connection with the suffering of the animals, because it's that connection that is recognized by the courts through Mr. Chernov's victory in the Glickman case. Every checkmark here reflects a violation noted by the United States Department of Agriculture. So we created this summary exhibit. And then I always include a little bit of excerpts that no one can ever read because they're too blurry of the type of violations that USDA was noting as reflected by those check marks. So food storage area that was dirty, flies everywhere, feces everywhere. Um, Importantly, a lot of the animals that got sick at the Cricket Hollow Zoo were usually injured by their own enclosure because it was so poorly constructed, and then would get into their own feces because the cages weren't cleaned. That wound would get infected and it would not be treated, and they would eventually succumb to death because of that uh, untreated infection. And then, of course, we had to have an expert. So here's our expert testifying about the psychological distress that these lemurs were experiencing in isolation. I always joke that we established a right to family in this case for non-human primates because what we established was that the Endangered Species Act, through its harm and harassment prohibition, protects a non-human animal's right to socialization, a right to have peers around them in order to meet and express their natural behaviors. And Dr. Klopfer himself was distressed by the conditions of these animals. At first, he had told us, I'm very busy. I have to run the Duke Lemur Center. I'm in charge of all these students at Duke. I just can't take time out of my day to become an expert witness. But that night he went to sleep and he couldn't sleep. And the next day he called us and accepted the case. This remains the only case he ever handled um, for anyone who went to court. Like, this is the only time he ever served as an expert. So we did win on these points, and the judge ruled that the Selners could not own endangered species ever again, and that remedy would redress the injuries of our individual plaintiffs who had sued under the Endangered Species Act. Whenever I tell this story of this case, people want to know what happened to the other animals. The answer is we then proceeded under in state court with a public nuisance theory to sue the Cricket Hollow Zoo and rescue the rest of the animals. We felt that the evidence that we had gathered in the federal case was strong enough to prove that the Selners were neglecting the animals under the state's animal cruelty code, which qualified as a per se public nuisance. And the court agreed and shut the whole zoo down and gave us access to recover all of the animals in the zoo. So the Cricket Hollow Zoo no longer exists and there's no animals there. And the people who own that zoo are not allowed to own wildlife ever again. So that is a successful case under the Endangered Species Act, where standing was really important. It was the first time we did this. The next case I'm going to talk about, and I might be going a little fast, so I apologize for that. But this is Bear Warriors United versus Alexis Lambert. She is the director of the Florida Department of Environmental Protection. Under federal law, you have to sue an individual. You can't sue the state itself to get yourself into federal court. So you have to sue an individual who's responsible for the violation. Here we sued the director of the Florida Department of Environmental Protection. Importantly, the stated purpose of the Endangered Species Act, in addition to the way that the take provision works, is to implement the purpose of the Endangered Species Act, which is to provide a means whereby the ecosystems upon which endangered species depend on can be conserved, to provide a program for that conservation, and to take such steps as may be appropriate to achieve the purposes of certain treaties and conventions. So the purpose of the Endangered Species Act includes habitat protection. So with that understanding, our client, Bear Warriors United, Inc., saw that the state of Florida had wholly failed to regulate sewage entering the Indian River Lagoon, which is the primary habitat for the West Indian manatee population. For birthing and nursing, birthing, for all their for reproduction and for the early stages of life of all manatees along the Atlantic Ocean. You can see the migration pathway is in blue here. Every single manatee that traverses this pathway, so all of the West Indian manatees spend their winter, at least some portion of their winter, in the Indian River Lagoon. It's the most important habitat for manatees in the entire United States. And the state had just wholly failed to protect it. So, real quickly, just to show you what we're talking about, these are on the left, you can see developments, agriculture areas, wastewater treatment impoundments, which is really what some of these little lakes are next to subdivisions uh, that drain directly into the Indian River Lagoon. And all of these houses were allowed to be constructed with what's called a septic tank, which is an on-site septic tank not connected to a central sewer system. So every single one of these homeowners in close proximity to each other like this has their own septic tank located on site that drains into this waterway and then eventually makes its way to the Indian River Lagoon. All of these agricultural lands that are spraying chemicals everywhere drain into the Indian River Lagoon. But for the most part, the primary culprit in the Indian River Lagoon is those septic tanks. So I don't know if the there we go. You can see over here how eutrophication works for the non-scientists in the room, but sunlight is important for the growth and health of all plants, including seagrass. Seagrass is the food that manatees forage on. They don't really eat any other food unless they're forced to. The nutritional density of seagrass is what they have evolved to consume primarily. When the lagoon fills up with excess nutrients, algae tend to eat those excess nutrients first, and then they form what's like kind of like a blanket cover on top of the surface of the water body, blocking out sunlight from the lower plants, which means that the seagrass are the first uh, species to die. They're almost an indicator species because they need so much of that sunlight. So over time, the Indian River Lagoon has turned into just a like a muddy mess lacking in oxygen. You can see these dead fish. There's an enormous amount of fish that have died off from the Indian River Lagoon. There's the manatee population has plummeted. There's mass die-offs every year. Um, and that made the situation sort of rife for individual plaintiffs who might be injured and member plaintiffs. But real quickly, just to show you, this is what the seagrass looks like in a water body. This seagrass is in a muddy water, like a algae-ridden water body. So it's going to die off. And you can see the percent coverage just plummet here in like the 2016-ish. There have been massive die-offs. This is a picture on the left-hand side taken by the Fish and Wildlife Conservation Commission in Florida of manatee necropsies. They're performing on manatee bodies that they recovered from the Indian River Lagoon in the background there. And on the right-hand side, this is a picture of manatees eating romaine lettuce that is being fed to them as a last-ditch effort to try and get them to eat something because there's just no food in the Indian River Lagoon. So the state tried to feed them supplemental feeding in order to save them. It did not work. Thousands of manatees died in the winter of 2021 and the winter of 2023. And at present, they're experiencing what will almost likely be called another unusual mortality event, which is when mass die-offs happen for baby manatees. Juvenile manatees are not reaching adulthood. So Bear Warriors United Inc. sued. In this case, it was not an individual plaintiff. So here, Professor Reddy's explanation of organizational and associational standing applies. We did not seek to demonstrate that Bear Warriors United itself had been injured by the government's conduct. Instead, we had three standing declarants demonstrate that they had been injured as members of Bear Warriors United Inc., so that Bear Warriors United Inc. could sue to stand in their shoes. The first was Katrina Shaddix, who is the executive director of Bear Warriors United. She testified that she used to fish, boat, and swim in the lagoon. She remembers softly waving emerald seagrass, crystal blue water. She just had this She's just so connected to this lagoon. She's a lifelong Floridian who only lived about 30 minutes away when she was growing up. She contrasted that against her experience as an adult when she was scared that her son might get an infection from all of the E. coli in the lagoon from the sewage discharges and lamented the loss of the manatees. She was so upset she conducted her own investigation of the 2021 mass die-off, documented a lot of carcasses that she sent to the Fish and Wildlife Commission, and sent to her supporters, and got a bunch of advocacy work going, including a food drive and her own supplemental feeding program to try and save the manatees. So we were able to demonstrate that she had experienced this interpersonal emotional connection to the lagoon, the water body itself, and the manatees, which had been injured by the Department of Environmental Protection's failure to regulate the sewage flowing into the lagoon that killed the seagrass. She had so many great pictures, and I pulled a couple of them, but this is a picture of a manatee that would normally be in the Indian River Lagoon, but had swam upstream into the Econ River to try and find terrestrial, so land-based forage that he could eat because he wasn't able to find seagrass in the lagoon. So you see a manatee surfacing and coming out of the water, hoisting himself on land to try and eat these grasses that are not part of their regular diet. And then this is a shot she got with a drone operator of the manatees in all those little specks are manatees gathered in the warm water refugia of the North Indian River Lagoon. In the past, that was green. It was covered in seagrass, and now it is yellow. There's no plant matter at all. So all of those manatees were likely starving and going to die. And she was heartbroken over this. She cried, and she did a great job on the witness stand. Well, theoretical witness stand, but Laura Lee Thompson. So the interesting thing about the Endangered Species Act and injuries in general is aesthetic injury is one way that you can get standing to sue, but economic injuries are like a higher level injury. So if you have somebody who's been economically injured by government conduct or by the defendant's conduct, you can demonstrate that economic injury. Even a scintilla or a nominal economic injury can often be enough to launch you into the standing land where you don't have any concerns at all. And that's what we had with Laura Lee Thompson and Gregory Flung, who we'll talk about in a minute. Laura Lee Thompson was a fifth generation Floridian whose family had always operated a commercial fishing operation and a seafood restaurant. Over time, because of the die-off in the lagoon, the fish disappeared and she was left with just shrimp. And her restaurant started to suffer because there was no tourism in the area because the manatees had died. Her testimony was really compelling and really effective. She also was an activist. Because of this impact on her business and on her livelihood and on her family's history, she started a program in the Mosquito Lagoon where she would help volunteer to plant seagrass in the lagoon beds because the Mosquito Lagoon is a different part of the Indian River Lagoon. There's like four different parts, and activists are trying to train the animals to go to the Mosquito Lagoon, which is further away from the sewage discharge, and so therefore a little bit healthier. So they're trying to bring the seagrass beds that used to exist in the North Indian River Lagoon to the Mosquito Lagoon to sort of help the manatees. So obviously her injuries were real, concrete, particularized, and caused by the FDAP's failure to regulate and redressable in our opinion and in the court's opinion. And then finally, Mr. Flung was a adventurous tourism boat operator. He did kayaking tours and manatee encounter tours, and he had no business. His business was destroyed by the fall of the decimation of the Indian River Lagoon and the loss of manatees there. So the Florida Department of Environmental Protection asserted a number of affirmative defenses, but they did not dispute the fact that the sewage discharge had killed the lagoon. They did really heavily focus on standing. They moved to dismiss the case for lack of standing. They moved for summary judgment for lack of standing. And at trial, after we rested our case, they moved for directed verdict for lack of standing. At each stage of the litigation, the court said they have standing. They have proved an injury, in fact, to their aesthetic, recreational, and sometimes economic interests that was caused by FDEP. We all admit that, even you admit that, FDEP, and that was redressable by a court order. But they really took issue with the redressability piece. And they argued a couple of things. So they argued first that um, the recent Supreme Court case law in the TransUnion case required that the plaintiff demonstrate standing and injury linked to each remedy they sought. So we sought four remedies. We asked for a moratorium on the construction of new septic tanks that flowed into the Indian River Lagoon. We asked for a supplemental feeding program, and we asked for medical monitoring of manatees. Those three conditions would stay in effect until the Florida Department of Environmental Protection could get a incidental take permit under the Endangered Species Act to operate their sewage regulatory plan in connection with that permit. An incidental take permit under the Endangered Species Act requires the preparation of a habitat management plan in connection with activity that takes a species to minimize or mitigate against the take. So we argued those four things in totality and even individually would reduce the take of manatees. The state argued that an incidental take permit permits the ongoing take, and so it would never the remedies laid out by the Endangered Species Act itself could never redress our injury. Therefore, we would never be able to prove or demonstrate that the injury was redressed. And that issue is on appeal to the 11th Circuit, along with other issues. They included a number of issues in in their uh, their briefing, which you just saw on the prior slide. But I always think it's interesting to show folks that this is a big case because, you never know what's going to happen in your litigation. You hope you win, and it never really occurs to you that winning will mean a lot of a lot more chaos, perhaps is the right word, than you anticipated. So the Florida Department of Environmental Protection hired outside counsel for the appeal. It's on appeal to the 11th Circuit right now. We argue in April in Atlanta, Georgia. The department got a number of amici, including the Pacific Legal Foundation, the Florida Home Builders Association, Florida On-Site Wastewater Association, Property Environment Research Center. But we also got a lot of amici. So we have the center, several water keepers and river keepers, the Sierra Club, and then several law professors at various legal institutions across the country were willing to stand up and put their name on the brief. So with that, I'm happy to take questions with Professor Reddy.
Wonderful. Thank you so much, Jessica. And thank you for all the work you're doing on behalf of animals and the environment. It's really inspiring.
Oh, thanks.
So I'm excited to start off our Q&A. I will just remind everybody, to the extent you're able to turn on your cameras, it's nice to see faces. I understand sometimes it's not possible. This is a good time to do so if you are so inclined. You can put questions in the chat. You're also welcome to raise your hand and we'll sort of go one by one. You can verbally ask your question by unmuting. But to get things started, we have a question from Maria in the chat that I will read, and I think it's to either or both, whomever would like to answer. So the question goes, strategically, is there a danger of a prospective plaintiff, quote, overdoing it and coming across as the stereotyped, quote, bunny hugger? This question comes from a longtime defense lawyer, 100% on the plaintiff's side here. Relatedly, is it better to describe them as non-attorney advocates insofar as an activist might have negative connotations to some?
Yeah, I can answer that. No matter what we do, there's just zero that we can do to avoid that accusation. We're constantly accused of being biased and extremists, and we just let the facts speak for themselves. It's really important in the actual on-the-ground representation to not be hyperbolic and to sort of even sometimes I sometimes have to tamper down my passion for the issues because I need to come across as even more um, thoughtful and together than you're allowed in other cases, maybe. Because what you're trying to do is make a big difference for animals, but you don't want the court to think that it will be that big of a difference. You want the court to think it's just going to be,
Mm.
the next thing in the line of things that doesn't really make that big of a wave. Courts don't like to make waves. So it's our job sort of to just absorb those accusations and just move forward with, thoughtfulness and compassion, but linked with total professionalism.
Yeah, and the only thing that I'll add, and I'll echo all those comments, if we look at the dissent in the Glickman case, which we both talked about, the dissent in that case observed that, there's nothing I think that's ever going to make this Janov person happy. Like, how do we know that,
Yeah.
even if the court required the USDA secretary to promulgate, regulations that did this, that would make, Janov happy. And I think there's a valid argument there, but, the majority said, that's what the law is intended to do, to provide some sort of measure of enjoyment for the viewing public. And if we don't acknowledge that, then, what does an aesthetic injury really mean? And so, it's not a good thing, but, once, we got past the standing requirements and were able to sort of litigate on the issues in the Glickman case, Glickman, Arjunov lost on the substantive argument. The court said, the regulations promulgated by the USDA secretary were, good enough, such that they had done what the law required. And so that sort of, bunny hugger, even if that were true, the court didn't necessarily accept that uh, as an element in their analysis, at least the majority.
Thank you. Kind of going off this a little bit and maybe coming from the perspective of this webinar series being focused on folks who are sort of adjunct professors teaching animal law, and standing being a very complicated question. You both did such a great job of making it seem easy. I know it's not. Is there a case or cases that you would say are the most important for your students to know or to learn in the context of standing in animal law? And I might start with Raj on this, but Jessica, I'm interested to get your thoughts as well.
I think for me, well, it depends on the the students who are in the class and what their perspectives are. As a professor, one of the things that I try to do is encourage students to, question some of their assumptions, even if it's to get them to arrive at answers that make them more firmly entrenched in their views. And so I really do look at the Naruto case as a really important one for us to consider, about what it means to take on an animal as a client. And when we think about, and when we call animals voiceless and helpless, what does that mean in terms of the requirement that we should have for ourselves ethically and as our duty as lawyers to be representing them appropriately? Um, and in and of itself, and with respect to that particular case and the statute in question, but also because, a number of other courts, even at the state level, so we're not even talking about federal statutes anymore, and the ALDF, Justice v. Vircher case here in Oregon, the concerns that the court raised about, how do we know that you, ALDF, are the appropriate, or that Mosman, that you are the appropriate sort of guardian for this horse justice who's arguably been abused by, their former owner. How can we rest assured that you have their best interests at heart, that you're the appropriate sort of representative? And, in substantiating, that concern, they pointed to the Naruto case and cited, several qualms that both the majority and the concurring opinion voiced. And so I think it's really good for us to be thinking about those questions critically, broadly, and again, in particular for my classes, which I'm very lucky. Most of the students who are in my class, they are self-described animal advocates, animal rights folks, and I think it encourages them to think critically about, their positions on these issues, after they graduate and, move into some of these organizations and are going to have sort of a seat at the table.
Thank you.
Yeah, I mean, the quintessential cases on aesthetic injury, Glickman and the Kiel v. Salner case and their progeny, I think, are really important for understanding aesthetic injury.
Mm.
But aesthetic injury has its limits, and so the real rubber hits the road. In addition to the animal as plaintiff cases that Professor Reddy indicated, but associational standing and organizational standing on behalf of animal interests has been very difficult, predominantly because of those prudential tests. So I'll tell you about a case that I filed against the United States Department of Agriculture's Forest Service because they wanted to and did shoot wild cattle located in the Gila National Forest and Gila Wilderness area from a helicopter. They claimed that they weren't able to round them up because of the rugged terrain, and so they needed to shoot 150 to 200 cattle out of a helicopter. My client was the Humane Farming Association, and those statutes that applied to this activity were the National Environmental Policy Act and the Wilderness Act. So we had to argue that those statutes protected the interests that my client, the Humane Farming Association, cared about, which included the humane treatment of animals in wilderness areas and not using helicopters in wilderness areas. And our judge was skeptical and ultimately found that we didn't have standing to pursue those NEPA arguments. He said that the Humane Farming Association's interest in farmed animal protection wasn't germane enough to the purpose of NEPA. So we're on appeal to the 10th Circuit on that question, and very hopeful that the 10th Circuit will disagree and find that, their interest is in farmed animal protection, and these farmed animals were at issue in a case that the Wilderness Act prohibits the use of helicopters and other motorized vehicles in wilderness. So, it didn't. Hopefully, the 10th Circuit allows that connection to be made, but it might just be disparate enough that they don't. And that's an important consideration too. And you can learn a lot from cases where you lose about who the ideal plaintiff should be if you're trying to do something to protect animals. I'll
And
also
yeah,
add though, just real
no, go
quickly though,
ahead. No, no,
it's
please.
very hard to find individuals who will jump on the lawsuit with you. So the more we can do to get associational standing, the better, because the associations are the ones that want to sue. So, sorry, go ahead, Professor Reddy.
No, no, no. No, I think that's a great point. And, along with, the dissolution of sort of Chevron and with respect to, I forget the name of the case, concerns mifepristone and Haven's organizational standing. Some in that case was decided 6, 8 months ago. I can't remember, but within the past year or so. Uh, where these doctors, this conservative group, physicians, were trying to sort of manufacture sort of their own standing through sort of the Havens argument, like directing funds um, uh, uh, to be able to or spending funds to uh, talk about the dangers of mifepristone to their patients and things like that. And so the Supreme Court, I think, appropriately sort of struck that as like that's not an appropriate application of Havens. But some scholars have said, well, this might be the end of Havens, altogether. And so something for us to be on the lookout for as animal advocates, particularly if you're working with an organization, how much longer can you sort of lean on that? And are we appropriately potentially like reading the tea leaves here? So important to have sort of these foundational animal law cases, but then also be interrogating these cases outside of the animal law context.
Yeah,
Thank you.
Mr. Hopkins just asked in the chat if there are any examples where courts set precedent that was harmful to animal advocates, and the case that Professor Reddy was just talking about would be top of the line. So I always say those, like Havens standing, which is a type of organizational injury that the Supreme Court recognized first in Havens, is the quintessential thing, standing jurisprudence that nobody wanted to break. And we were all very careful about how we argued it, when we used it, when we didn't use it. And these doctors came in and just bulldozed it out of their own selfish interest in FDA versus Alliance for Hippocratic Medicine without a thought. They, I think people don't always know because they don't read the opinion carefully, but one of the findings of fact in the Supreme Court opinion is that the doctors spun up the nonprofit they used to sue 2 days before they sued. That is not an injury to an organization that has a, I mean, they literally did this in order to be able to sue because they thought the Supreme Court was in their pocket. And in doing that, we have this new case that applies to all of us. And that makes it a lot more difficult for organizations to sue.
Wow. Well, thank you for that. Obviously, we're very much on track with the questions in the chat, and I think Kathy shared here maybe the case name is the FDA versus Alliance for Hippocratic Medicine. Is that right?
Yeah.
Maybe sort of along these lines, and I almost hesitate to ask the question, so feel free to punt if you feel so inclined. But do you guys have thoughts on the future of standing and the doctrines of standing, given the current Supreme Court makeup, and what we're seeing coming out of there?
Go ahead, Professor Reddy, you go first.
I mean, yeah, I mean, we're talking in the federal context, and so it seems to be, yeah, it seems to be kind of bleak. But sometimes I'm surprised with this current administration, some of the issues that they sort of glom onto and the sort of weird bedfellows situations that seem to be happening. So, never say never. I will say, in light of some of these, I think it was the Ohio sort of Erie personhood development that was ruled sort of unconstitutional due to sort of vagueness and some of these other animal and environmental personhood cases we're seeing, I think Idaho and Utah and maybe some other states now developing sort of anti-personhood laws that, include, for better or for worse, animals, the environment, or bodies of the environment, and AI. And so some of these states being proactive, knowing that this is an issue that's, potentially coming to their jurisdictions.
Hmm.
I would agree that things are a little bleaker than we'd want them to be, but the Alliance for Hippocratic Oath case or Hippocratic medicine, actually, I mean, it was bad, right? It's bad for activist organizations, but at least the Supreme Court wasn't just giving their ideological partners what they wanted wholesale. Because before that case, I would have assumed that they were going to craft some rule that allowed standing for those doctors, but not for ALDF, right? But instead, they said, no, this is too far, not for the doctors either. So I don't know. I try not to have too much hope or expectation in these times. But at the same time, I try to see silver lining where I can.
Yeah, and in terms of the hope and the silver lining, I'll say really compelling developments overseas. I mean, just what a week ago, Peru, through ordinance, recognized the legal personage of, I think, some of these native stingless bees, and that
Mm.
being, exceptionally compelling, particularly for someone who teaches insect law and seeing these advancements. And so, my hope is that enough states or enough countries, global states, will usher forth these developments that it won't be so dramatic and like surprising to see here, sort of incorporated or integrated into the United States.
There's one more question in the chat from Maria, that I might let you take a look at, talking about a McIver versus Murphy Brown case, nuisance claim, and asking could they have argued standing for animal welfare claims. I don't know the
Actually, no, I'm not familiar
case.
with this case. Yeah, I
Yeah,
don't
so I
know
don't
if.
know. But
I'm not
maybe
either, but I could guess. It looks like the nuisance was probably a traditional nuisance, and she's wondering if they could also have argued if that like the neighbors were suffering from a nuisance as a result of like animal welfare concerns. I think the answer, if that's the question, is yes. without seeing it, I would always advocate that someone try to shoehorn like animal welfare concerns into a nuisance theory based on a nuisance per se claim. This is what we did in the state court public nuisance claim in the Cricket Hollow Zoo case in Iowa, which was upheld by the Iowa Court of Appeals, and then the cert petition was denied to the Iowa Supreme Court. So it's good law for all purposes in Iowa. If we can do it in Iowa, I feel like you can do it anywhere.
I'm from Indiana, and I feel that sentiment sometime being from a fellow
Yeah.
I state. Well, so just real quick, want to circle back to something Paulina said at the beginning, the student perspective, talking about how having a grasp on the practical and functional sort of role of what standing is maybe supposed to do had helped her in learning the doctrine of standing and trying to apply it. So I just didn't know if you guys wanted to take a couple seconds and from your experience, either teaching or in the practice, what the role of standing is from your lens as a way to sort of maybe put a happy bow on the end of our time here together.
Well, I would say that, I mean, I don't know if it's a happy bow, but I think that standing is a doctrine that has developed over time to pick winners and losers.
Mm,
Fundamentally, it can go either way. You'll not understand sometimes why you lose a case because it matches the same fact pattern or it seemed like a natural extension of something that happened already, and yet you lose. And I'll point you to the Illinois case that I did with Professor Waters, actually. We were arguing that an aesthetic interest in rodeo animals being treated humanely confers standing on our client organizations to challenge the issuance of a permit for the rodeo to continue operating, even though it was causing the intentional harm to animals. And I won't go into details about the underlying facts, but the Court of Appeals in Illinois decided that there would not be an aesthetic injury recognized in that state as to animals. Just not at all. They're just not going to do it. So we obviously didn't appeal that to the Supreme Court out of risk that the Supreme Court would agree, and then there wouldn't ever be the possibility of that happening again. And we left it where it was as case law that applied to the permitting scenario only. But that's nuts. So, I mean, the judges at the Court of Appeals asked me in argument, you know, are you asking, they said, you're asking us to recognize something new in Illinois, aren't you? And I said, yes, but you will be the only state that said no to this question if you say no. All of your neighboring states and all of the federal district courts that have ever considered it have said yes, and you'd be unusual in that regard. And they said no anyway. So,
wow.
Yeah, I mean, I think I would echo a lot of those sentiments. And, what I encourage my students to do, and we do this in my fundamentals class, we examine sort of standing in sort of the human interested context outside of sort of animal issues. So humans, corporations, organizations, and then to try to appreciate, why some of these barriers or hurdles are there, why these requirements are
yeah.
there. And then, you know, what is the court and the justice system not considering when we're talking about the interests of non-legal entities, whether those are animals or whether that's the environment, or environmental bodies, and what sort of more ethical or robust jurisprudence are we trying to usher forth, and how can we potentially do that given sort of the rules and the framework that we're operating within? And I think that can be, yeah, maybe demoralizing for some, but also kind of exciting for others because there are, just like with the justice case, I think it's an excellent argument. And so, how can we, because we have to be, really creative, out of the box thinkers, how can we sort of be required to, but also exercise those muscles on behalf of animals? And so I think there's a really compelling intellectual sort of argument in this field like no other. And so it's one of the things that I think keeps it fresh and keeps it frustrating also for students and professors, but also makes it really enjoyable.
Well, thank you for that. Thank you to both Jessica and to Raj and to Paulina, who had to leave us a bit early because as a responsible student, she had to go to class. So we tip our hat to her. If you have friends and colleagues that couldn't join us here today, please let them know that the recording will be available. And please join me in thanking our two wonderful panelists, Jessica and Raj, for a great session. Thank you, guys.
Thank you.
Thank you.